Welcome to Hull Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada from the offices of Hull Hull in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull Estates and Succession Planning. I'm Ian Hull, and some of you may be listening or some of you may be watching our video podcast for this week. You'll see a couple of changes in the podcast format today. One is we're missing Suzana, who is tied up in client meetings, and we had to go to press before I could get her out of her meeting. And second of all, the sound, we're having some troubles with the sound. So this week hopefully will be the only week that we have trouble with the sound. We'll have it fixed for next week. Today I wanted to talk a little bit about what we're going to try to do more of in our podcasts and our videos is to talk about some upcoming events that we're going to be speaking at Hull Hull and for Hull Hull, and also talk about the topic that we're going to be dealing with. For example, next week I'm going to be speaking at the Law Society on a Practice Gems course for wills and estates lawyers, and it will be videocasted and also for those attending. Suzana is the chair of the program next week, and I am speaking on a very isolated topic and an interesting topic from my perspective, and I think one that many people run into on a day-to-day basis, either hearing about it in the news or hopefully not, but maybe even hearing about it in their own family situations. And that is non-traditional wills or testamentary documents. And what I want to talk a little bit about is the concept itself, because we're very familiar with the idea of a will. You know, lawyers, pages of words, signed at the end, witnessed by two people, and it's usually got a nice, pretty cover on it, and all of a sudden it's a real will. What I'm talking about are the documents that find themselves in the scenario where they're a will, but it's not in the traditional form, in the non-traditional documentary form. And the categories that we see, of course, the most obvious one is that we would see as what we call are the pre-printed, or what would have been known as the stationary or the grand and toy wills. Another type of non-traditional will is a holograph will. And that is a will that we'll start with. And that concept comes out of the Succession Law Reform Act in Ontario and is widespreadly accepted across many, many jurisdictions in Canada and the United States. The concept that is that if you do your own will, you handwrite your own will, it may be a valid testamentary document. And what Ontario, our test really comes down to is number one is that it is wholly in the handwriting of the individual. So the individual has to have written out the document themselves, and is it signed by that individual? And does the will express an intention for it to be testamentary-like? And that's vital to wherever anyone is going to analyze a piece of paper. If I look at this piece of paper here, and it had some writing on it, and it had my signature at the bottom of it, is that going to be sufficient to be a will? And those are the kinds of cases that our office deals with from time to time, and how to administer those in situations where it's not contentious, and how to administer them when it's contentious is another question. Obviously, it is better to have the good old-fashioned, pretty, properly prepared will by a lawyer. It's better at a bunch of levels. First of all, the courts know how to accept that document much more readily. Second of all, third parties, banks and so on, can look at the document and have some comfort and familiarity with it. But I'm going to talking about the non-traditional, the holograph or the pre-printed will. So the holograph will, it can happen from time to time. Where we see it a lot is when a husband and wife are separating, and for example, the wife comes to see their lawyer. He's a family law lawyer. He doesn't know anything about drawing wills. And she says, well, look, I'm separating from my husband. The lawyer looks across the table and says, have you got a new will? And the wife goes, well, what are you talking about? Well, does your current will give everything to your husband? Often the case that the spouse goes, oh my gosh, that's the last thing I want to have happen. And so sometimes in that scenario, a family law lawyer will say to their client, well, before you leave, I want you to handwrite a will right now that sets out how you want to dispose your estate. Often it's a situation where you might be giving it to kids. And so the will gets dictated or gets worked through by the lawyer just as a temporary holograph handwritten document so that it instantly changes the existing will, which in my example, of course, is a will that would have gone all to the husband when the separating wife simply didn't want that to happen. So there's an easy example of where a holograph will gets used in our practice, and sometimes that person doesn't go and get it updated, doesn't go and get it formally done. So what have the courts done with those documents is, first of all, judges want to, as best they can, embrace intentions that are testamentary, whether it is in a perfectly formed document or it's in a holograph will. So what will often happen is they will step back and say, all right, let's not just discard this handwritten note. Is it something we can turn it into a real will and tell the world that it's a real and proper will? Number one is it all in the handwriting? Number two is there a signature? And then number three is, what is the language that's being used in it? And the courts play with that question, that third component, because the courts want to look to what is the intention? What is the expectation? Is this just a nice note from a grandmother with a wish list saying, I'd really love you to have the grand piano? Or is it a will-like document that is enforceable, that means that you're gonna get the grand piano? And that kind of attention in the courts and the analysis that the courts go through is what the courts struggle with. The language is clear. So often people will put in a holograph will, this is my last will and testament. And sometimes we see them where they've just simply copied those kinds of opening words. Describing it as a will helps a lot. Using words that are final and fixed help a lot. But you can see how that language and that whole uncertainty of a written will can bring with it uncertainty in the courts, uncertainty with your estate plan, uncertainty with the third parties who are going to deal with this document as a valid will, or is it really just a nice birthday card from Granny talking about the grand piano? We continue to press our clients and say, fine, in certain circumstances, illustrations that I've just given you, the holograph will is a great idea, but move forward and get the formal document. Because if we don't, we're going to run into stumbles, added costs, added uncertainty to your administration. And you can see I've identified three core, and there are more, but three core elements of a holograph will. Otherwise, it's fatal. Just doesn't work, and the document's not going to survive. And that can't be what you're hoping to achieve when you take even the limited time it takes to write out your will in a holograph form. The second component of these non-testamentary documents ties to the pre-printed form will. And as I said earlier, that's the grand and toy type will, we used to call it, and to give them the plug, it's sort of like a Kleenex in terms of a term of art, or a stationary will. And in those cases, the courts really have struggled with how to take those documents and use them because of the competing interest of it. Part of it's in typewritten, and part of it is in handwritten, and what parts prevail and what parts don't prevail. So at my next podcast, I'm going to start with that topic and talk about the struggle with these handwritten and typewritten co-wills called stationary wills. But I wanted to make sure that we focused on the holograph will today, and again, as an encouragement to everyone to avoid seeing someone like us or seeing a lawyer with your mom's will that is in handwriting and may or may not be enforceable because of technical legal rules that your mother didn't know of when she was handwriting it at the time. So thank you very much for joining us. Hopefully we'll have our technical glitch fixed for our next podcast, and I look forward to Suzana's return. Thank you.
You have been listening to Hull on Estate and Succession Planning by Ian Hull and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.